Justice will demand that both parties are allowed to present their arguments in support of their respective cases based on evidence, based on verified evidence. I therefore find merit in the adjournment only for that ground and in the result, a ruling pending a response from the state. The matter is therefore adjourned to 13th of June at 10 a.m. to allow the prosecution to make a response for the bail application, and a ruling will be made thereafter on the same date.
By 3 lawyers, Omulamuzi Bwamuzizaayo, and Reverend.
Okay, we have appeal Caroline for state. And then?
Omulamuzi Bwamuzizaayo.
For the accused?
Yes. We had done the application today on account of the fact that the state was not in court. I was not in court.
Yes.
The accused person is seeking the admitted bail on the following grounds. The offense is charged with spyable and disobeyable and summary of court. She is the mother. The businesswoman. Entering in land, research. Iona has got a number of sympathies in Omulamuzi. Maama, she is the mother of the accused person.
Who is the mother of the accused person? Can I have any document or an ID so I get the name correctly?
Local council 1. Tete Parish. Our division. The whole district. Our telephone number is 075 64 79 58. Our NIN number is CF 600 52 10 AGV AC. And the medical facility there, particulars are not there. It's a disease which is a bit rare, which is rare. So medication is a bit of a challenge, even when one is out. She's also a grandmother. She looks a little bit young. She's a grandmother. She has some grandchildren who she's taking care of. And the toddlers are just. I wonder if next. Pray that you want to grant an application on such terms that you are allowed to go and come back as charges.
No?
Sorry?
I'm looking for that in this particular case. Never face me exercise. Preparing. And up it. I respect to them. Have they application? Yes, we are going to calculate the mandate effectively. Respond to this application according to the contract statements tendered by the council for the accused person. For how do you think?
Council Mungoma can rejoin.
Yes, when I have a agenda, and I remember when I was at law school, we were told that all arms which handle justice should exercise equity. There should be fairness. We should investigate fairly. The prosecution, you should prosecute fairly. And the court and the advocate should also present this case fairly so that all parties that are involved in the criminal justice system and whoever watches sees that there is fairness in the whole process. And therefore people trust the system. Your Honor, in the first appeal here, the sanctions, the charges were sanctioned in the morning, the state.
subsection 1 of the Penal Code Act, which is an offense triable by this honorable court. As such, this honorable court has jurisdiction to entertain the charges, as well as the authority to consider this bail application. I agree that the accused person has a constitutional right to apply for bail, but court reserves the discretion to consider whether or not to release the accused person on bail. In exercising this discretion, I'm aware that the same must be done judiciously upon considering the nature of the offense, the circumstances of the commission of the crime as it can be ascertained, as well as the substantiality of the sureties presented, among other grounds. The tests that court usually invoke is whether or not the accused person shall turn up for trial if she is granted bail. If there is a likelihood that the accused person will appear, then the accused person will be granted bail. But where there is doubt that the accused person will jump bail, then it will not be granted. In the instant case, counsel Mongoma for the accused has presented a total of 4 sureties who is submitted will ensure that the accused person shall turn up for trial. The prosecution, however, submitted that the investigating officer is preparing an affidavit, but she did not divulge the details as to what the said affidavit shall constitute. She also submitted that she would like to verify the documents which have been submitted before this court and pray that she should be given an adjournment and she will be ready to respond for the next adjourned date. I have considered the charges preferred, although I find the basis for preparing the affidavit by the investigating officer submitted by state to have no substance, since the reasons have not been disclosed. I find the argument of verification of documents to have substance. This, in my opinion, is necessary so that the claims made in the said documents are confirmed. The prosecution may not be in position to verify the same, owing to the fact that such documents are usually presented before court at the time of preparing or making this application. I am also mindful of the fact that the last time this matter appeared, the state was not represented. The last time this matter came up, the state, before court, the state was not represented and may not have had time to address her mind to the matter before court. Justice will demand that both parties are allowed to present their arguments in support of their respective cases based on evidence, based on verified evidence. I therefore find merit in the adjournment only for that ground, and in the result, allow the adjournment for state to respond and accordingly decline to make a ruling pending a response from the state. The matter is therefore adjourned to 13th of June at 10 a.m. to allow the prosecution to make a response for the bail application, and the ruling will be made thereafter on the same date. In the result, the accused person is hereby remanded to prison until then. It is so ordered. Call the next file.
This is Uganda versus Crephoco. Ismail.